On Tuesday, May 28th, the Karen Reed trial continued with day 18 of testimony. Still in the prosecution's case in chief, the jury heard from 8 witnesses on day 18. Then they heard from John O'Keefe's niece and nephew. And after that, we finally got to hear some testimony from some medical professionals. But is it convincing for the jury? Keep watching, and in the end, I want to know what you think. Let's get into it. Okay, so to begin, the defense picked up where they left off with Brian Higgins' cross-examination. Apparently, Jackson was called back to Los Angeles for some other cases he has, or maybe he went for the holiday weekend to see his family after being away for the past month. I'm really not completely sure about the reasoning for it, but the important thing was Yannetti picked up where Jackson left off. And when he did, Yannetti of course started by hammering immediately on the topic of the phone. For one thing, Yannetti got Brian Higgins to agree that in September 2022, he was served with a preservation order for his phone. And Brian also agreed that after September 2022, he never actually received anything that canceled or lifted that preservation order. And the reason that Yannetti pointed this out is because this means that Brian would have had really no reason to think that it was okay for him to toss out the phone if he didn't get anything from the court that basically told him that it was okay to do whatever he wanted with the phone. And yet, as we know, after September 2022, Brian made the decision on his own to get rid of the phone. Anyway, Yannetti also asked Brian whether he did a factory reset of the phone before throwing it away. Brian denied that, so Yannetti brought in a report from a statement that Brian made to the police on May 5th, 2023. When Brian said that he couldn't really remember what he told the investigators during that interview, Yannetti introduced it to Brian to refresh his recollection.
Having read that document, sir, does that refresh your memory about telling those people in May of 2023 that you did do a factory reset of your phone?
That's not accurate. I did not tell them that. And I also didn't tell them that I saved texts with my father.
All right, so your testimony is that they got it wrong, correct?
My testimony is I didn't make those statements.
Your testimony is that they got it wrong, yes or no?
Objection.
Sustained.
Well, in any case, you took the SIM card out of your phone, correct?
No, what I testified to was that it's...
Did you take the SIM card out of your phone, yes or no?
I don't know.
Did you testify that that's what you do when you get rid of phones, sir?
What I said was that might have been the extent of it if I was to have done that.
And you either cut up the SIM card or ripped it up, correct?
I believe what I testified to was I would have...
I'm not asking you what you testified to. I'm asking you today, did you either cut up the SIM card or rip it up?
Cut it up or broke it.
Okay. And you will agree with me that cutting up or breaking the SIM card destroys the SIM card, does it not?
The card itself, yes.
That would have been the purpose in terms of cutting it up or ripping it up, to destroy it, correct?
Well, so nobody else could use the phone.
Well, that was my next question. But
In another phone.
But the purpose of cutting up or ripping up or the SIM card is to destroy the SIM card, is it not?
Yes.
And you wanted to make sure that somebody couldn't put that SIM card in their phone and potentially access your data, correct?
No, that wouldn't be the reason why.
Okay. Well, we already talked about the fact that you testified under oath on June 1st of 2023, correct?
Yes.
And you were under oath when you were testifying on June 1st of 2023, correct?
Yes.
You swore to tell the truth?
Yes.
You raised your right hand?
That's correct.
And June of 2023, June 1st of 2023, was about a year ago, correct?
Yes.
It was about a year closer to your throwing your phone away, correct?
Yes.
And in that testimony that you gave in June 1st of 2023, did you say the following, quote, I made sure that somebody couldn't put it in their phone?
Yes, I did say that.
In fact, by either cutting up or ripping up your SIM card, you also knew that that SIM card couldn't be put back in your phone either, correct?
Yeah, I believe that would be correct.
And you'll agree with me that you took that destroyed SIM card and put it in a trash bag, did you not?
I believe it went in a trash bag, yes.
Well, you used the passive voice. It went in a trash bag. Did it fly out of your hand unexpectedly into a trash bag, sir?
No, sir. It would have been disposed of with the phone.
No, I understand. But are you reluctant to say that you put it in a trash bag, sir?
Objection.
Can you answer that? Are you reluctant to say that?
No, Your Honor, I put it in a trash bag. Or with my
And
trash.
then you also took your phone, now without the SIM card, and you put that in the trash bag too, did you not?
Yes, sir.
Now, we've heard this echoed several times from other prosecution witnesses so far, where they say, no, I told the police one thing and they reported something entirely different. It does seem that there is some sort of an endemic problem with the police in Massachusetts, either adding erroneous things that the witnesses didn't tell them or leaving out things that were said to them. And oddly enough, it does seem that these things that are getting left out or are improperly added are all important details. Now, we do know that Canton PD particularly is terrible at investigating crime scenes.
Solo cup, I fill you up.
But these witnesses seem to be suggesting that this is more widespread of an issue than just the evidence gathering. I mean, either that or all of these witnesses are lying when confronted with these inconsistencies. Either way, this is not good for the prosecution. Anyway, Yannetti also hammered Brian Higgins on the topic of him removing the SIM card, destroying it, and throwing away both the SIM card and the phone, all on a military base.
Then you drove to a military base and you threw both the destroyed SIM card and the phone into a dumpster, did you not?
Well, I was cutting through the base, and I believe how I testified
Did you drive
was
to a military base, sir?
I was cutting through a base, yes.
Did you drive to it?
Yes, sir.
And then you put both the destroyed SIM card and the phone itself, which were in a trash bag, into a dumpster on that military base, did you not?
I believe that's what I did, yes.
And as you were driving away, you knew that that destroyed SIM card and the phone would be gone forever, correct?
Yes, I threw it away.
And before you drove away, you did not transfer anything from your old phone to the new phone, correct?
That's correct.
You lost all of your photos on that phone, did you not?
Whatever photos I had on there, I did, yes.
You lost all your videos on that phone, did you not?
To the extent if I had any.
You lost all of your other text messages besides the ones that you had with Karen Reed and John O'Keefe, correct?
That's correct.
And you knew that you did have text messages on that old phone with Kevin Albert.
He's a friend, most likely.
You also had text messages on your phone with Nicole Albert.
Most likely, yes.
And you had text messages on your phone with Brian Albert.
Yes.
It was important to you that no one see those text exchanges that you had with those three members of the Albert family.
Objection.
I'll let him have it.
No, sir, that's not true.
You took no steps to preserve those text messages, did you?
That's correct.
You did not ask your friend Matt Kelch, the agent, to help you extract those text messages, did you?
That's correct.
And when you went to that machine, you did not extract them yourself, did you?
He walked me through it. I did do the extraction.
You did not extract the 3 strands of text messages with Nicole Albert, Kevin Albert, and Brian Albert to preserve from that machine, did you not?
No, I did not extract those.
So the only place you knew they existed was on your old phone, correct?
Yes, that's correct.
The same phone that you put into a dumpster on a military base with a SIM card removed from the phone and destroyed, correct?
Well, I did throw the SIM card and the phone on the military base.
Right, and the SIM card was destroyed. You've already testified to that.
I said to the extent of if I did that, I would have done that.
And we're talking about the actual phone that would have had your text messages, again, with Brian, Nicole, and Kevin Albert, correct?
Yes, because the motion was denied.
Well, you've already testified, sir, earlier that you never received anything in writing that either canceled or lifted the initial preservation order, correct?
That is correct.
You knew when you were throwing that phone and the destroyed SIM card in the dumpster that from that day forward, no one would ever be able to access the content of what you and Brian Albert had discussed by text messages on your old phone, correct?
Anybody.
I have nothing further.
So, okay. Let me talk for a minute about my personal experience with military bases. I am not in the military, but I am married to someone serving on active duty. And because of that, I have access to military bases. And I will tell you that in my experience, which is admittedly anecdotal, there's been no cutting through a military base. There are reasons why I might decide to go to a military base specifically. For example, for cheaper gas or cheaper or better groceries. And on redirect, Brian Higgins did say that he often goes to this military base to throw out his trash and to get cheaper gas. In my experience, going out of your way to throw your trash out on a military base is kind of a huge annoyance. And the only reason why I can accept this to be some sort of a reasonable explanation is because he apparently has the ability to pay or not pay for trash pickup at his home. And I guess apparently Brian just doesn't pay for trash pickup at his home. I don't know why someone who's been working for the federal government for several decades would be that cheap, but maybe he is that cheap. However, the idea of cutting through a military base is strange to me personally because in my experience, driving through a military base is not exactly convenient. First, you have to stop your car at a checkpoint. Then you have to get your military ID scanned. Then you have to wait for them to check your car. And sometimes there even is a line at the checkpoint. So you have to wait for this process for several cars before you. Then when you're on the military base, you also have to be very careful about the speed at which you drive because military bases have notoriously low speed limits and military police tend to be much more watchful and strict when it comes to speeding than the regular police are. So based on my personal experience, I am somewhat skeptical of someone who says that they are cutting through a military base as if it's some sort of a shortcut unless they're already there for some other errands. Anyway, that's all for Brian Higgins. The next two witnesses were John O'Keefe's niece and nephew. And because these two are minors, there was a protective order in place for their testimony. Under this protective order, the media was not allowed to televise or audio record their testimony. So the journalists actually sitting in the courtroom were not allowed to live tweet or take any notes on a computer during this testimony either. They were apparently allowed to take notes on pen and paper, but the notes that they took were not allowed to include any sort of personal identifying information about the minors. And this is one reason why I'm referring to them here as the niece and nephew of John O'Keefe, even though their names have been spoken many times in this case, and even by the prosecution, which was the side that actually put the protective order in place in the first place. So anyway, we were not able to watch this testimony, and for plenty of good reasons. So we'll have to just rely on the media reports about it to see what they testified about and how this all went. Anyway, the next witness was Dr. Justin Rice. He was the ER doctor who treated John O'Keefe when he arrived at the Good Samaritan Medical Center. And I'm not going to lie, for me personally, this direct examination was difficult to follow. This is a witness who seemed to know what he was talking about, but who has a very low skill in explaining medical terminology, treatments, and more to a layperson. And now this is kind of a common experience in trials when you have a witness who is testifying about some highly technical information. This is true whether we're talking about a lay witness like Dr. Rice or an expert witness even. If we are lucky, we get someone who is both knowledgeable in their field and is able to communicate that knowledge to a layperson so that they can understand it. But that's not always the case, and that was what happened with Dr. Rice. And on top of that, Dr. Rice also has this manner of speaking where he has this tendency to start a sentence, then veer off in the middle of a sentence in a different direction, and maybe return to end the sentence that he started off saying. However, this particular direct examination was done by ADA Adam Lally, who actually has the same tendency. So this made the direct examination actually pretty difficult to focus on and even more difficult to retain the information. And again, all of this does end up with the jury. And the question is, how can they be expected to see the evidence from the prosecution's perspective perspective if their attentional energy is being overtaxed during the testimony. Okay, so anyway, let's get into some of these details about Dr. Rice's testimony. Dr. Rice testified that John was unresponsive and intubated when he arrived at the hospital around 6:45 a.m. He also explained that John had a problem with his perfusion. From what I understand, perfusion is basically the passage of bodily fluids, most notably blood, through the body. And when there's an issue with someone's perfusion, there's a risk that the organs will shut down and the brain will experience brain death. And so it sounds like that's basically what happened with John here. Anyway, Dr. Rice also testified that John was hypothermic at about 80 degrees Fahrenheit. He said that they tried warming him with a bear hugger, which apparently is a blanket filled with warm air. But as you can guess, this was not exactly successful. Anyway, when he was reading the medical report in the courtroom, here's what Dr. Rice noted of John's injuries.
Yes.
And as far as this is sort of a listing of observations or, well, let me ask you, can you describe what is listed at the top of that page there?
Sure. So this would have been the physical exam documentation of my note. So, with respect to the head, it says, excuse me, the first word is other, which I believe is a function of the computer system. As in, I typed in the right superior orbital ridge region, approximately 7 millimeter laceration, and then with surrounding soft tissue swelling / contusion.
Sir, if I could just stop you there. As far as what you're talking about with the right superior orbital ridge region, could you explain to the jury or demonstrate to the jury?
Sure. So the orbital ridge is the bone above your eye that you can, like where your eyebrow is or should, would normally be.
And as far as the other sort of things that you noted over the course of your physical exam or review of Mr. O'Keefe, what, if anything else of note, did you observe?
Well, according to my note, the only other kind of observations other than would be that he had breath sounds present bilaterally. I observed that he was pulseless. His abdominal exam was atraumatic on my chart, and then extremity exam or musculoskeletal exam, I wrote that he had superficial abrasions on the right forearm.
And from a medical perspective, when you use that term abrasions, so can you explain to the jury what you understand the term abrasions to mean?
Yeah, I use it as a medical synonym for scratches, if you will.
And under neuro or neurological, there's a listing as far as a GC3, is that correct?
Yes.
And can you explain what that is and what that means?
So, GC is what I charted. What I intended to write there was GCS, which is a Glasgow Coma Scale, which is a scoring system to identify someone's level of consciousness or unresponsiveness.
And as far as the three, where does the scale start? Where does it go to, and where does the three fit in?
So there's three components: verbal function, motor function, and eye or ocular function. And someone who's completely unresponsive, as in no motor, no verbal, and no eye movement or function, completely unresponsive, the lowest you can get on the scale is 3.
Now, on cross-examination, defense attorney Elizabeth Little asked about a few things. And most important for the defense was basically 2 points. First, she asked whether he recalled an EMT telling him that he thought that these injuries were a result of a motor vehicle accident. This is a reference back to the EMT testimonies from a long time ago, where one of them had said that he followed in to the Good Samaritan Hospital and basically told the medical staff before leaving about that. However, Dr. Rice said that he had no recollection of being told anything like that. Then Little indicated that if an EMT had given him this kind of information, it would probably end up in the medical report, would it not? Although strangely, Dr. Rice said not necessarily. So Little needed to push him on cross to basically reveal why this answer was weird, since having the information about the cause of the injury is helpful to know that they can properly treat the patient, and it would help them to be on the lookout for potential hidden injuries, for example. So it was kind of strange that they pushed back on that, but it is what it is. Anyway, the other part that Little wanted to go over was the fact that he didn't note any injuries below John O'Keefe's neck other than the scratches to his right arm. Dr. Rice also pushed back on this, but ultimately they went through John's body point for point to show that he didn't indicate any injuries to any of these parts below John's neck. On redirect, Lally did elicit from Dr. Rice that Dr. Rice may not have noted these injuries because he was mostly focused on life-saving treatments for John. But considering the fact that he did note the laceration above John's eye and the scratches down his arm, this still was admittedly a bit of a weird response. But anyway, that was Dr. Rice. The next witness was Dr. Gary Fowler. He was the chief pathologist and medical laboratory director at Good Samaritan Medical Center on January 29, 2022. Basically, his testimony was all about drawing Karen's blood and looking at it for the alcohol content. Now, Dr. Rice, the previous witness, had actually also testified to seeing Karen Reed at the hospital since she was subject to a Section 12 psychiatric hold. And so part of the overall evaluation for Karen Reed was this blood draw. Now, apparently there are two ways to draw blood for purposes of a blood alcohol concentration test. There's doing a whole blood draw, and then there's doing what's called a serum test. A whole blood draw is where they draw someone's blood and then take the blood alcohol content as measured against the entirety of the contents of the blood. For the serum test, however, they basically take out everything from the blood but the water and then test the alcohol content in the water. And because the alcohol apparently kind of sticks to the water as opposed to the rest of the blood parts, that's where they'll find all of the alcohol. Apparently the reasons why hospitals will do this is because it's pretty cheap and efficient to run a test this way. However, they are using it for basic diagnostics and not for forensic value. In other words, not for use in a legal case. And here's where things start to get a little bit tricky for both sides. Apparently, the hospital in this particular case ran a serum test on Karen Reed's blood. And this measured her blood alcohol content around 9 a.m. that morning. But what came out on cross-examination is that hospitals basically are not allowed to, or at least have a general policy against, doing a calculation to convert their blood alcohol numbers into what could be used for, say, a DUI charge. So we have a possibility here of a limitation of applicability of this kind of a test to a legal case such as this one. At any rate, Karen was found to have 93 milligrams per deciliter of alcohol in her blood. Now, another thing that came up on cross-examination was another possible limitation of the serum test in this particular case. As it turns out, the serum test doesn't even test the alcohol in the blood directly. Instead, it measures something called NADH, which is a byproduct of alcohol. And the thing is, NADH can apparently also be elevated by factors other than alcohol. Some of these other factors include lactate and LDH, as well as some hematological problems and high levels of lipids and bilirubins in a patient. Now, Dr. Fowler did say that their serum testing machines are sophisticated enough to detect some of these other factors, and he did say that there were no interferences detected in Karen Reed's blood. However, Little did also bring up a good point on cross-examination that sometimes things like trauma, muscle weakness, and abnormal muscle tissue could also interfere. And so it wasn't all that clear that these other factors could be detected even in these sophisticated machines. And so where we're talking about a patient who has MS, which is a disease that impacts muscle tissues, and where we're talking about a patient who was obviously traumatized, this can start to call into question some of the applicability of these results. Anyway, the next witness was Nicholas Roberts. He is a biomedical forensic toxicologist for the Massachusetts Office of Alcohol Testing. And so his testimony was really a continuation of Dr. Fowler's testimony on Karen's blood test. Basically, what Mr. Roberts does, as is relevant to this particular case, is he receives blood tests from hospitals and other places, and he performs serum conversions. So although the hospitals have a policy against doing those kind of conversions from a serum test result to basically translate it into like a whole blood test result, Mr. Roberts is a guy who can do them. And before I get into the details of his testimony, I will say that Mr. Roberts was probably the best witness for the prosecution that they've put forward. His competency and his ability to communicate his knowledge and expertise reminded me of Miss Kuhn from the UC Davis Veterinary Lab. However, I do think that Mr. Roberts' skills in communication and teaching the jury even surpassed those of Miss Kuhn. And honestly, after the previous two medical witnesses, he was such a breath of fresh air. Anyway, here's what he did for the conversion of the serum test. So he first took the results of 93 milligrams per deciliter that the hospital got from Karen's blood. He also noted that the blood test was taken at 9:08 a.m. on January 29th, 2022. And then he used mathematical magic because, in my opinion, math is magic, just like science is sorcery, to convert this to the typical BAC levels for forensic purposes. And because this is a result of a mathematical calculation, Mr. Roberts did say that they can't get precise data on this. All they can do is end up with a range of BAC levels. And so he said that at 9:08 a.m. on January 29th, 2022, Karen's blood appeared to have a range of 0.07 to 0.83 BAC with an average of 0.081. Now, that's not the only calculation that he did, because he apparently was also asked to do a retrograde extrapolation. This is where he takes that converted BAC level and basically counts backwards to see where her levels were at the time of her last drink. And here he said that Karen's last drink was at 12:45 a.m. And so he calculated backwards to figure out what her BAC would have been at about 12:45 a.m. on January 29th. What he calculated this to was a range of 0.135 to 0.292 BAC. I will say that is an insanely high number. And if this number does accurately represent her BAC levels at that hour, that certainly is over the limit for a DUI. However, getting to that calculation also requires a number of assumptions, as Mr. Roberts acknowledged on cross-examination. And remember, there is a possibility that at the beginning of this test, that this is flawed as well due to Karen's personal medical record. And what's more, Mr. Roberts acknowledged that an individual can also be an outlier from the ranges calculated because of their individual characteristics. So it will be very interesting to see if the defense is able to introduce some concrete information from her record to add some heft to this idea of this flaw in the testing. But anyway, another thing that came up on cross was where Mr. Roberts got the bit of information that Karen's last drink was at 12:45 a.m. Specifically, he noted that he was given that time as her last drink. It wasn't reported directly by Karen Reed for that to be her last drink. And on cross-examination, he did acknowledge that the timing of the last drink is pretty crucial for this calculation. In other words, if Karen Reed did have a drink somewhere between 12:45 a.m. and the 9:08 a.m. blood draw, this entire calculation is completely wrong. Already, the timing does sound weird because the incident was supposed to be around 12:30 a.m. So I'm not sure where anyone got this 12:45 a.m. detail. And so we'll see if the defense introduces some kind of evidence of Karen going home and, I don't know, drinking by herself. Anyway, the seventh witness of the day was Michael Trotta. He is the superintendent of public works in Canton, Massachusetts. He basically oversees all of the operations of Canton's roads, sewage, etc. And so he basically was there to testify about the snowplow logs to show when and where the snowplow driver drove in front of 34 Fairview Road on January 29th, 2022. Mr. Trotta testified that Trooper Michael Proctor called him for this information and he handed it over. Interestingly, though, on cross-examination, he also said that he couldn't recall specifically if Proctor had ever asked for the name of the snowplow driver who plowed 34 Fairview Road that day. However, he did testify that he may have actually told Proctor who specifically plowed the road.
You spoke with him over the phone only, correct?
Yes.
He never came down to the DPW to meet you in person, correct?
Not me, no.
And he never asked to interview any of your employees, correct?
We may have discussed who was on that route and who plowed, but I'm not sure at that time if he had told me he was going to go talk to anybody else.
Oh, so it's your testimony that you may have told him the identity of the plow driver when you spoke with him on February 3rd over the phone?
I may have, but I am not positive.
You don't have a memory of him asking you who the plow driver was?
He asked, no. No, I don't have a memory of his exact questions.
But leaving aside the exact wording of his questions, it's fair to say you don't have a memory of him asking you who plowed Fairview Road on January 29th. Is that fair to say?
He asked me about, I believe he asked me about this plow list.
About the what? The plow list?
This plow list.
Right, but on the plow list, there's the name by the yard, correct?
Yes,
All right. There's also, to the left of that, an indication of the name of the plow driver, and it's just a first name and a last initial,
Yes.
correct?
yes,
It doesn't spell out the whole last name, does it?
no,
But you know the full last name, correct?
yes,
You have a limited number of employees, right? It's not a 1,000-person company, right?
yes,
All right. And you're well familiar that Brian L. is Brian Laughlin, right?
yes.
As you sit here today, do you have any memory of whether the name Brian Laughlin was brought up during that phone call with Michael Proctor?
I may have said to him, that's who BL was, but I did refer, I believe I referred him to the operations manager to double check who was on plowing that day.
Okay. You say you may have mentioned the name Brian L. or Brian Laughlin, but again, I'm just trying to drill down on what your memory is. Do you have a memory one way or the other as to whether the name Brian Laughlin came up in that conversation?
If you are asking me, do I remember 100%? No.
Okay.
And this is interesting because I do recognize the name Brian Laughlin on the defense witness list. So I'm wondering if there's something to his testimony that's likely to be beneficial in the defense's case. And if it turned out that Proctor was given the name of the driver and either didn't investigate further to talk to that driver, or worse, tried to bury that information, that is not going to be a good look for the prosecution. But we'll see as this case continues to unfold. Anyway, the final witness of the day was Louis Jutras. He is the IT director and information systems manager of the finance department in Canton, Massachusetts. Basically, he was there to introduce some surveillance footage of the road in front of the Canton Library on the morning of January 29th, 2022. And he testified that he was asked to pull for basically 2 different time periods on that day. Those were between midnight and 1 a.m. and between 5 and 6 a.m., both on January 29th. This footage got introduced and the prosecution played a couple portions from it. But I have to say, it's not exactly clear to me what the prosecution is planning to do with the surveillance footage because the portions that they showed didn't seem to show anything of significance. And I will say, Mr. Jutras did testify to a couple points that seemed to get ahead of some of the defense's likely criticisms of this surveillance footage, particularly about potential gaps in the footage. He did testify on cross-examination that he basically just looked at the start and end times for each time period that he was asked to pull. This was just to make sure that he cut it at the correct points, apparently. However, he did also testify that he didn't watch them all the way through each hour to ensure that they showed the complete surveillance footage for each hour. And on direct examination, to kind of get ahead of this part, he testified that it's not uncommon for these surveillance cameras to go down several times a year. Things just happen with their maintenance and whatnot. But on cross-examination, he testified that he never cut any portion of this footage out of what he turned over to the Massachusetts State Police. So on cross-examination, the defense seemed to hint pretty hard that there was something wrong with this footage. And so I have a sense that we're probably going to hear about some pretty significant gaps in the footage and that it therefore can't be relied upon. Overall, today was a day that the prosecution wanted to get points on the board specifically for the DUI charges. But I personally have some reservations about the fact that they used the serum test and had to rely on those mathematical calculations, which could be altered by a number of different factors. And like I said, if the defense does provide evidence that Karen, say, started to drink in the early morning hours because she was worried about John or something like that, that's going to basically throw out all of this forensic evidence for the DUI charge. But those are my thoughts. What do you think? Do you think that the serum test is reliable? What do you make of the testimony about the snowplows and the surveillance footage and whatnot? Let us know in the comments down below. Otherwise, I hope you enjoyed this, or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more daily coverage of the Karen Read murder trial, both in daily recaps and in gavel to gavel live stream coverage, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out. See you on day 19.